So, welcome everybody to Spin Legal. This is our show every Wednesday evening about 6:30ish. We don't promise to an exact start time like I try to with Talking Niagara, but hey, Spin Legal is 6:30ish on every Wednesday, and today is Wednesday 23rd of October, and this is episode 39, as best as I can make out.
We're going to have to be more regular with our times.
With Angela and myself, and we are partners at Invictus Legal. And tonight our topic is commenting upon the fact that Toronto is following Hamilton's example of creating a renoviction bylaw. So we're going to look at some of the questions that brings up. So I'm intrigued by this because as you know, I'm definitely intrigued by municipal law, and I do a lot of work in municipal law. So if you need to contact us, you can do so at Invictus Legal on 905-688-5598. Email Angela at weareinvictus.legal, or me at Peter at weareinvictus.legal, or go to our website at https weareinvictus.legal. There you go.
Yep.
Okay. So here's the question. Toronto. So essentially the topic today is Toronto follows Hamilton's example for creating a renoviction bylaw. And that was actually a news item that was in 2 or 3 areas of the press. We saw it on CP24 lunchtime when we were just kind of snacking on a sandwich, and we thought, interesting topic, let's go and dig a bit further. So what is happening here is the City of Toronto on the Planning and Housing Committee sits on Wednesday, October 30th, which is next Wednesday at 1:45 p.m. And they will have this as a topic on that agenda. And that will be considered by the full council in November. So there you go. Thought you might want to know that. I'll give you the link of the city council if you're interested in it. So there we are. I'm going to drop the link into the city documentation. So follow that if you're interested, and up to I'll leave it to you guys. All right.
And this is something what we tend to follow through and so forth, because our firm is involved in municipal issues, and people sometimes call us for municipal licensing issues or picking up permits and different things like that. So we help them with some of these processes. So we try to keep abreast of a lot of these major developments.
And I certainly believe that if we do end up with a with the licensing aspect through the municipal law, I and others on our firm can help you. And let me just welcome, as always, Robert. You're always welcome, Robert, and I hope you're fascinated by this week's topic.
And I want to let them know that Robert lives in Hamilton, and Hamilton has one of these bylaws, and is the first one to create a bylaw like this. So this would be of great interest to him.
Yeah. Okay, so a question here is, let's put out a definition so that everybody knows, what is a renoviction?
A renoviction is when a landlord decides, it says, I got tenants in these fourplex that I have. I'm getting about half the rent that I should be getting, because it's still below market. But what I really need to do is I really need to gut that whole building, and I need to get the tenants out while I'm gutting the building so that I could then move people back in. So basically what it is, a renoviction is where a tenant is not allowed to exercise their right of right refusal. They don't get that privilege, or they're not informed of that right. And they do a lot of they go in there and they do some renovations, and maybe they'll give it a fresh paint job, or maybe new
That,
floor, new
okay.
carpet.
I'm sorry, Angela, but you have taken one of you've been negative and slanderous about what a renoviction is. Let's gonna be So I'm
Well, that's why they're setting these bylaws,
yeah.
because it's a suspicion that that is what's taking place.
Well,
And the
yeah,
reason they're setting these things is the municipalities are concerned that some of that is happening
yeah.
and that tenants are being thrown
The
out of their
true
low cost housing into the streets.
the true the true nature of a renoviction is, let's say you've got a triplex or something that you've got a number of tenants that have been in this triplex, and part of this triplex, you bought it from somebody who created this triplex 25, 35 years ago, and you bought the triplex, but you've looked at the triplex and you think to yourself, well, there's the back stairs on the triplex are dangerous. The this and that and the other is so out of date that I need to do the whole thing up. And in thinking about it, you're actually saying, well, I believe that in fact I'm better be suiting the tenants more if I were to do this or that or the other to the triplex, and maybe I need to make it into a fourplex rather than a triplex, and then I would be serving the community better, because I can then have 4 one-bedroom rental units, which enable us to to solve part of the housing problem that we have in this area. So that's broadly so that's generally what a landlord may well want out of a renovation. So
And
they're
many
looking at,
times we do have that. We
yeah,
have people in the community who are trying to build housing, and this often happens where a landlord is genuinely trying to do something to solve the affordable housing problem in the community. Okay. But what these renoviction bylaws are, and they're called renoviction bylaws
yeah,
because, for a large part, what they're trying to prevent is these evictions based on renovations. Okay. When in fact, the law under the Landlord Tenant Board generally does not allow you to take to renovate a place as a reason to evict a tenant. Okay,
by the
so
way,
what they're trying to do is trying to stick the something in there, the putty in that little hole there, the little loopholes that some of the landlords use. So this is to protect the interests of the tenant. But although there is some questions, there's a lot of questions
yeah.
about this because there are
Okay,
legitimate
so
landlords. Are we
first
pricing
challenge,
landlords out of
first
business?
challenge of the day, Angela.
What?
First challenge of the day. Are you going to write to the Oxford English Dictionary and to Webster's to suggest that the new word of the year for 2025 is renoviction?
I'm sure that they use that a lot. I mean, I'm sure it's already somewhere in the Urban Dictionary,
Yeah, Urban Dictionary, but not necessarily the other one.
the
Okay.
Webster's or
Yeah,
whatever.
yeah. Okay, so a renoviction is basically, there are genuine reasons for renovations. And like I said, the person who's turning a threeplex into a fourplex, or maybe fixing problems that may exist in older units. We've seen a few where, the renovations are there to improve and generally try to improve the neighborhood. We deal with renovations from both sides of the floor. So we help landlords and we help tenants, that's for sure. So we know a little bit about it, right? So renovation bylaws, there are clearly some reasons for it, because we know that there have been some skirting of the system, let's put it that way. Angela?
Yeah, there is something. And what they're trying to do is trying to cut that out and then try to, if someone's trying to legitimately do it, try to give a process to it. Okay,
Yeah.
same as municipalities have a process to apply for various forms of licenses for businesses, for Airbnbs, for various things that they do. Okay, some of them even have rental licenses. at the city of Brampton and the city of Thorold, actually. So they
Well,
do.
one of the questions about when you look at what they've done in the city of Hamilton, I get that they are looking out. They're trying to look out. They say when the bylaw comes into effect, tenants will be issued who have been issued an M13 notice can contact the city staff to ensure their landlord is in compliance with the renovation license and relocation bylaw. That's what they call their thing, renovation license and relocation bylaw. And until the law comes into effect, tenants facing bad faith evictions under the guise of a landlord requiring vacant possession to repair or renovate a unit are encouraged to contact the landlord and tenant board. Well, I would go further than that. Landlord and tenant board is not going to assist any tenant facing legal problems. Go seek legal advice.
Yeah.
Doesn't have to be from us. It doesn't have to be from us. It should be from a paralegal or lawyer that is competent with not just landlord and tenant law, but specifically with renovictions.
Yeah. And also might be able to assist in understanding the bylaws as well.
Yeah. Municipal bylaws are actually that's a very important thing that you just said, because municipal bylaws by themselves are actually a whole new ball game, and probably the vast majority of whether you're a landlord or you're a tenant and you're facing the question about bylaws and use it for renovation licenses or renovation relocation licenses. The question, you should be basically finding somebody who actually does know about municipal laws and understand, and they can assist you through the process, because whether you like it or not, there's going to be potentially some application of licenses that may well be needed, and we'll discuss some of the challenges relating to bylaws later on as we go through this program. All right, but whether you're a tenant or a landlord and you're doing a renovation on a property, you could be affected by this.
And this is something that's very important because all these laws change all the time. Our office is always in continuous updating mode.
Yeah,
always learning the new laws and how they work, which is why we try to understand them so people can call up, and then we're usually have the up-to-date information.
And just to be clear, on the actual agenda, on the summary of the bylaw, the bylaw, the rules are actually in front of the Toronto City Council next week. Says that the report responds to the June 26th City Council directive to staff that they develop a Hamilton-style renovictions bylaw and implementation framework to protect tenants and prevent renovictions. A renoviction is when a landlord illegitimately evicts a tenant by alleging that vacant possession of a rental unit is needed to undertake renovations or repairs. Right, so they've added the word illegitimate. The question here is that it's up to the land. What the emphasis by the city of Toronto is that it's and also therefore by Hamilton is that it is up to the landlord to prove their case in front of City Hall.
Yeah. So what they're trying to do is saying, okay, we will allow you to do this, but we want to have legitimate work being done.
Yeah.
Okay. So if there's illegitimate work being done, you not only get in trouble with the landlord tenant board, but you might also get in trouble with the municipality as well.
That's going to be an interesting one. So we look at the way that the Hamilton bylaw operates. The Hamilton bylaw states that within 7 days of issuing an N13 notice for demolition, repair, or renovation purposes, landlords must apply for a renovation license from the city. Now, let us be clear. There's been one or two instances where I've known from cases we've dealt with where a landlord has issued an N13 and then realized, oh, there's an error. Either there was an error on the N13 or the N13 wasn't the right way to deal with the problem.
Yeah.
Right. So they've essentially retracted the N13, because an N13 notice that is given to the tenant in and of itself isn't actually the be all and end all. The tenant isn't evicted at that point. Right? The eviction only occurs at the behest of the LTB. And that's an important thing to remember. So just because your landlord has issued you with an N13 doesn't mean you walk out on the day, you know, day and date. You should get legal advice.
Yeah, exactly. Read the form, and if you feel that you've been wrongly given the form, or you feel that the form may be given to you in bad faith, or you don't really believe that any repairs will be done, you know, or there's something cynical about the whole thing, just take it to a legal rep and they will explain what your rights are.
And the cynical,
if they've even filled out the form right, because many times they don't.
And the cynical sort of thing might well be as much as, hey, the last time the landlord was here, he muttered about how I'm only paying $750 rent on my unit, and right at the moment he could easily get $3,000, $4,000 for my unit on the open market, and how I'm a drain on his resources, or diary, that kind of thing. That actually is relevant information. That is something that can be used in a case. You know, if you decide to challenge your N13.
Yeah,
and besides which,
I've had N13s denied before,
as
well as N12s denied.
Yeah,
for many reasons, because things have to be done in good faith before the board.
Yeah.
And you can't be doing things like where I'm just going to renovate, or I'm going to have my son move into the unit. Meanwhile, the son lives up in Japan somewhere. And yeah, he's going to come back from Japan to live in a 1-bedroom unit that you have. And he has a beautiful property in Japan.
Yeah, he lives in Kyoto, and on a 15,000 acre in a 15,000 acre plot in a mansion. Yes, yeah, he's coming back to a Hamilton 1-bedroom flat apartment. Yes, of course he is. We believe that. We believe that is blind faith. Absolutely.
Yeah, there's always these things, you know. That's why we have to work through it. That's why it's important that you work with a legal professional if you feel that this is crazy, or if you've been served a number of these types of notices and they keep getting turned down, or if they keep saying, oops, I made a mistake. Oops, I made a mistake. Or they keep saying, I want my son to move in, then the next one they send you, they want their daughter to move in, or something like that, you know.
Yeah, well, actually, one of the questions about an N13 notice, if you're a tenant, keep every one of these notices that a landlord gives you. You just never know when they, you never know when they might well have their value.
Yep.
But if you get an N13 notice, I would suggest to you that probably the best thing to do is book a consultation with a paralegal or a lawyer who understands landlord and tenant law, and bring that to them. Have them, show it to them. Tell them the facts of the case, and even if all you do is have a consultation, take that consultation. Get some advice about what your next steps might well be.
Mm-hmm.
Right? Because at the point where you get an N13 notice, well, that might not be terminal, right?
Mm-hmm.
And your paralegal will now have to go and look at the city bylaw, to, and city licensing, to see whether a licensing application has been made.
Yeah, and see if it met any qualifications. Because if the city looked at it and said, no, it doesn't qualify for a license, that could be an issue too.
Well, actually, that's going to be one of the biggest challenges, because what do you do? And we'll come to that in a little while. What do you do when there's a conflict between the province and the city? That's going to come up. Okay, so looking at the Toronto renovations bylaw, as I said, it's being considered by the Housing Committee on October 30th, and the full council in November.
Yeah.
Right. And we
and provided they were positive about this, the new bylaw probably won't take effect until July 31st, 2025.
Yeah.
But it takes time. You have to take a lot of steps to discuss a new bylaw, get consultation, go to the appropriate committees, and then go to full council, and have legal look at it, and a whole bunch of things. So these are some of the steps that Toronto is taking. Hamilton's been in place for how long? A few months now?
Hamilton's bylaw is, just let me see when this will be in. Right, so will come into effect on January the 1st, 2025, to address bad faith evictions and protect tenants through the new requirements for landlords who want to complete renovations and where vacant possession is necessary and required to do so.
Yeah, and so you got one coming in January and the other one coming in July of next year. So by the time July comes around, we'll have a few months of seeing how the Hamilton bylaw works and seeing if it has, in fact, prevented some renovictions, which might be a good thing to see, to see how effective that is. Okay? But we'd only have a few months to take a look at that.
Yeah. And by way of shameless advertising, Invictus Legal provides assistance with your municipal legal matters as well. It's one of the areas that I specialize in, is municipal legal matters. And if you need, by the looks of it, you're in Hamilton or you're in Toronto, and you're a landlord wishing to create an N13 and wishing to have your tenants out because of an N13, it's probably best that you not only contact a paralegal that has or lawyer that has LTB experience, but you also and experience dealing with N13s, but that you also need one who has knowledge of municipal law. And it's funny, I know a grand total of 2 people that have that combination. So I'm not the only one.
This is one other.
There is one other. I'm not going to give their name.
No.
I respect their ability to do
competition.
I'm not advertising for somebody else, but so this is my moment to advertise for Invictus Legal. So if you need us, just call
905-688-5598.
Yeah. Okay. All right. So the question I have is, the application for licenses can be I can see as being problematic. As they stated in Hamilton, they're basically saying within 7 days of issuing an N13 notice for demolition, a landlord must apply for a renovation license from the city. Now, I also then said, if you remember, sometimes we've had some landlords who issued an N13, then they came to a legal rep and they suddenly realized the N13 that they issued was wrong, was something that should never have been done. There was another way of dealing with the problem.
Yes.
Right.
Exactly.
And so therefore, if that was the case in this particular instance, that application, that license, if you have to go by the Hamilton law, you have to apply. Now you've done your N13. Oops. All right. But now you have to go and spend $715 and apply for a license
Yep.
that you actually don't need.
Yes, exactly. On a defective N13.
On a defective N13.
Or one that you don't need if you don't need to do the extensive renovations.
Yes, exactly.
It might be just something where, because it's quite extensive what they're asking people here. You have to have a building permit before applying for the rental renovation license. You have to obtain and submit a report from a qualified person, such as an engineer or a contractor, that does the renovations or can give an estimate to tell why the tenant has to leave the building, that they're so extensive that they have to leave the building. And you have to pay the fee, and then you have to post a tenant information notice at the subject unit to inform the tenant of the license application and enable the tenant to seek information about their rights, and complete a plan to provide tenants who choose to return to the units with temporary comparable housing at similar rents, or provide monthly rent gap payments based on post 2015 average market rents. Like, it's going to be quite involved. So if you're going to be going to do something, if you're in Hamilton and you're in Toronto, this is going to be quite involved next year if this is something that you want to do.
And I'm almost going to say to you, do not even think about issuing. No landlord in Hamilton or Toronto should ever personally issue an N13, right? If you
Even
want
before you look at the N13, talk to us first.
Yeah, talk to a paralegal first.
And then talk to us about what you need to do in your building, and we'll tell you what you need to prove what kind of work you need to have done first.
Yeah.
Before you do this, because we know that many of you are legitimate and you do need to do this work, but we want to make sure you do it right and you don't end up with costly errors or end up at the landlord-tenant board where they say, oops, wrong notice, and they dismiss your case after you spent all this money and time and effort, because that's what happens.
And we don't know what the fees are going to be for Toronto, and typically with other fees, I'm not going to make a prediction that they're going to be $700. In Hamilton, the fees are for cost of a renovation license will be $715 with an annual renewal fee of $125. Well, essentially, I can see, given that the typical thing of an N13 is that there is at least 12 months of repairs, so I can see that you would need a second year in such a circumstance,
especially if you're trying to add units or an extension, or clean the whole place out because it's outdated. Fire code. There's a lot of different reasons why you need to do this. And this 715, we don't know whether this is per unit, or whether it's period.
Whole block, yeah. And again, that isn't clear at the moment. And obviously, it's going to be, if you're dealing with a building that's got, say, 10 units in it, and you're creating, you're renovating it, and you're creating 12 units as a result of the renovation. We don't know how that 715 applies. Is it just for the whole building, or is it per unit, or is it per unit you're evicting people from? Because in fact, when you're creating new units, where does that come into play?
Yep, exactly, because there could be one unit being split into two, or you're going to enlarge one unit, or there's a lot of different things that can come out of that renovation.
Exactly. And some of these things are not easily known about. And for example, if you have a triplex where let's say the upper floor is just under the attic, but there are out of the bedroom out of one of the bedrooms, there's actually a staircase that leads into the attic. And you renovate the attic, does that become extra bedrooms potentially? Right? So those sort of things you could actually make into part of a renovation that could all come into play on this one. So there's a whole heap of issues that I think need to be, one needs to be concerned about. And one of the questions that I'm going to be looking at for whether it's the city of Hamilton or the city of Toronto or any other city that decides to take these steps, one of the questions that has to be answered is this: how does this renovation license apply? Because the renovation by its nature is limited in time. Whilst I expect it to be a year or two, I can't see it being 5 or 6.
Mm-hmm.
Right?
Yeah, exactly. Like these are things that, and that these are things that we want to see how it's going to work, and also how it's going to work in conjunction with the functions of the board.
Well, that actually brings us on to another question, because is it out of scope to create offences and for municipalities to create this bylaw? Surely this is something that needs to be in scope. It needs to be handled by the province, since the actual sole body that deals with all landlord and tenancy matters has to be the Landlord and Tenant Board.
Yeah, because right now, Section 168(2) of the Residential Tenancies Act gives the Landlord and Tenant Board exclusive rights to deal with all matters under the board, as well as with any issues that are dealt with under that jurisdiction of the Residential Tenancies Act.
Yep. Right. And as I said, with Hamilton, the cost of a renovation license is going to be $715 with a renewal of $125. And that's so we're yet to see how these problems, come out. And I'm probably going to be, I'm going to be reading the paperwork once we have the full bylaw wording. I'm going to be reading that bylaw by the end of the year, and actually be in touch with people at the Hamilton building and planning and building department in order to actually find how this is going to work.
Yeah, and then we would be able to turn around and talk to landlord associations and property management groups and so forth to discuss how that would work and how that it would impact on them.
Yeah, and it's important that we know how these are actually going to work. And I think one of the questions that we have is that where that jurisdiction is exclusively with the, for all landlord and tenant matters, is exclusively adjudicated by the LTB, how is that going to impact things?
Yep. Like they might look at things like sort of like the province of BC did, and where they put renovations more strictly under the provincial act, and they govern what they call the Residential Tenancies Board, which is like our Landlord and Tenant Board, and they have jurisdiction to manage that type of process. But bylaws and doing this, I don't know. It's called ultra vires. They could be found to be making laws that are totally out of their jurisdiction, and they could be struck down if it's challenged. Okay, but it has to be challenged in order to do so.
Yeah.
But
okay,
in the meantime, we have to comply until we don't.
Okay, so here's a question from Robert. Can a paralegal challenge the municipality's bylaw because it doesn't have jurisdiction? Now, yes, you can. However, it depends upon exactly how the municipality is going to create offences within the bylaw.
Yes, exactly. Right? Like sort of like a certain bylaw that Peter knows well about in the city of Niagara Falls.
Well, if a bylaw creates its offences and the offences are tried through the provincial offences, through Part 3 provincial offences, which is the only, if they're done that way, then you can certainly challenge them. You'd have to have a client, and you'd have to be able to have a client who was falling foul of the process, and through that client you can challenge them through the you can certainly challenge them through the
court, and you can also file it to the Ontario Court of Justice through the appeals process, which paralegals have jurisdiction in.
And the other question, though, is that you see, that's because when you've got an offence. But if you don't have an offence created, that's a very good question, because in fact, actually, what you're saying is that I want to apply and do this correctly as a landlord, but I don't know what the actual correct procedure is. And the question here is that what you would therefore do is I would almost suggest that what you need to start in terms of doing a renovation for any form of renovation where a person is likely to be evicted is, first of all, get the plans in order, get the application for the bylaw in order started before you even consider doing an N13. Right? Yeah. The N13 is about stage 4 or 5 during the process. You have to have created your application through the building department, through the planning department, whichever is the relevant department within your local city. You'd have to create the application there first before you do anything to do with an N13. So that application with the city for amendments to the, to adjust, to change the building would have to be done first.
Yeah, and it may very well be that after you get the green light from the city, then you can file it with the board.
Yeah.
Right, and then you can carry on your eviction. But we're going to have to find a way how this is going to work hand in glove with the landlord and tenant board and with the province.
Well,
the Attorney General
it's point out a definite problem there, Angela. The definite problem, as far as I'm concerned, is that it can take in order to get a building permit from the city. I've known, depending upon location, it to take 1, 2, maybe 3 or 4 years for a building permit.
Oh yes, right? I know what you're doing too.
Yeah,
I had I had a client that took about 2 to 3 years to get a demo permit, and they were building a condominium complex on McLeod Road.
Yeah,
up in Niagara Falls. So we assisted them there, and then I also helped them evict all the tenants with one holding the whole housing project up, multi-million-dollar project, and he kept holding it up.
But so basically, what the situation is here, that you may have to wait 2 or 3 years in order to get your building permit from the city. Now you're in a situation where you're ready to actually give the tenants their N13. Oh, and by the way, building permits have a time clock on them, don't they? So now you're ready to do your N13, and now you do your L2 application for each of the units in the complex, and you file that with the landlord and tenant board.
So the building permits have a fee to them, and the renewal has a fee to them. The renovation license has a fee to them, and its renewal has a fee to them.
Yep.
So what you're doing is adding to the cash cow.
Yeah, exactly. And then the question also then becomes one of, as I said, there's a clock running. There's a clock running on your building permit, right?
Mm-hmm.
So now, how long is it going to take for the landlord and tenant board to listen to your, your L2 application?
Yeah.
Right. First challenge, if you've got multiple units, if you have multiple units, you have to create the individual. You have to create the same application for. If you've got 15 units, you have to create the same application for 15 units.
And they always involve drawings and engineers things.
Everything.
Yep.
Everything has to be up there on the application itself. That has to be on the board. It has to be provided to the landlord and tenant board. Secondly, you have to make an application to the landlord and tenant board to have all of these units heard together, joint applications.
Mhm.
Because if you've got 15 applications and one of them is not heard at the same time as all the rest of them, you've got a problem. Right?
Yep. Or you want to have 15 different applications heard on 15 different days.
Yeah.
And that's just going to drive you nuts.
Yeah. Then you're going to actually make an application so you've made an application to join these together. Then you will make an application to shorten time. And the reason you make an application to shorten time is because how long is it going to take for a typical N13 to get through the landlord and tenant board?
It could take up to a year.
Maybe even 2.
Yeah.
Right? And remember that clock is ticking on the renovation license, and
meanwhile, you're paying more money for extensions and so forth.
Yep.
Okay, to get your thing done. And you're legitimately trying to do that.
Yep.
So what did our government say? Something about cutting red tape to build more housing or something?
I think Doug did say that. Yeah, Doug did
somebody
make that
said
point.
something about cutting red tape. So I don't know. It just seems to contradict what's going on here.
Yeah, that seems to be adding more red tape.
Yeah.
Okay. So next, an individual or corporation charged under the renovation license and relocation bylaw, which is the name of the Hamilton bylaw, by the way, may be subject to fines, penalties, and other orders. So here is going to be where it gets very, very interesting. You get your building permit. You apply, you give your N13s out, you apply for your L1 application, you apply for your license with the
L2 application.
L2 application, yes, thank you. And you apply for your license with the city. The L2 application is, of course, going to take months, and the city reviews their thing and says, denied. They've given you the building permit, by the way, but they've denied you the renovation license.
Yes, exactly. And that's all people need.
And furthermore, when it comes down to it, and the wisdom of the landlord and tenant board, some 18 months later comes along and says, I really don't care what the city thinks about this. Approved.
Yeah. Yeah, it is my understanding, like historically, that when people bring up, but the fire department said this, or bylaw said that, they don't care. They only deal with one act. And this is where it's going to be a challenge.
Yeah. Well, plus also we have to remember the Residential Tenancy Act already has applicable offences that can be applied to a landlord if they believe that the landlord is acting in bad faith. All right? And minimum, they could offer a $35,000 fine for every single unit that they consider the eviction to be in bad faith for.
Yep.
Right? Every unit, not 35,000 for the whole complex.
And this is in addition to what you might have to cough up to pay off the tenants.
Exactly. So you could end up paying 35,000 to the tenant, to each tenant, and 35,000 as a fine. And you put that together, if you're talking about a 10 unit building, and the landlord and tenant board denies you, at the end of the day, you could end up with owing the tenants $350,000 and owing the landlord and tenant board $350,000.
Yeah. And this is, I think, to some extent, this is put in deliberately and cynically.
Yeah.
Don't you think?
Yeah.
Okay. I can understand the intent because there's a lot of that going on.
Yeah.
But
The-
not every single landlord going in to do repairs is doing this.
So it leads to the question, what right do municipalities have to enact these rules?
Yeah. I think they're trying to say, okay, we're tired of all the tent cities being located.
And I understand that. I'm the
They're
first
seeing them
person to
being
understand that.
generated by renovictions.
Well, that's an unfair. I think that's an unfair. It's an unfair comparison. Certain renovictions, that's true that it does happen, but many other renovictions, there are landlords out there that are actually trying to, help provide
What if they are
new
creating
accommodation.
affordable housing underneath there? They get a federal grant, and the federal grant is there to help them create affordable housing. There's even a grant that people can get in the city to help them build
Yes.
ADUs and basement apartments and other types of things.
Yeah. So
Like
if you put all of these things together, we've got a potential nightmare here for for multi-level rule misunderstanding.
yeah, exactly. And this is where it's very important that if you have concerns about this, they have a place where people can write in and give input into this proposed bylaw in Toronto.
Yeah.
Okay, to talk about what your concerns are, and they have to look at it. They have to go through various steps to make sure you're heard.
And
And
just as, while we're talking about fines, etc., in terms of the current Hamilton bylaw that will be enacted on January the 1st, the fines for non-corporations range from $500 to $10,000 for an individual landlord, and $500 to $50,000 for a corporation. Fine amounts are subject to approval by the Ministry of Attorney General, by the way.
mhm.
Right?
I would think that the Attorney General would have to approve some of this and then enact that through the provincial offenses.
Well, that actually, to my mind, is problematic because it has to be done. Any charges and fines would have to be done through, in my mind, must be done through a Part 3 Provincial Offences Act.
Yeah, and I hope they don't create an AMPS.
If you try and do this through AMPS, I think you can have an aberration of a system.
Mm-hmm.
Right. And in fact, actually, with other municipal things that I've got cities, some cities like, some cities, not going to mention any name, some cities that do things by provincial offences routes, and other cities that do them by AMPS. And I'll tell you one thing, one of the things that AMPS is essentially just a money grab. Right?
Money grab, it's not even democratic.
Yeah. And AMPS,
what happens if you're not guilty of this?
Yeah. And
you can't challenge your guilt.
Yeah, you can't challenge your guilt. You can do a screening, but a screening basically means that you have to respond to your notice within 20 days. You have to do that. You can get extended time on a screening, but not much. So you can get, further. You could still be, as many of these fines are per day that you're not in compliance, right? Think about that. A particularly mind-numbing bylaw officer comes to your door on the 1st of July, looks over it, $5,000 fine. On the 2nd of July, looks over it, $5,000 fine. How quickly are you going to be out of business as a landlord?
Yeah. And this is stuff I feel is absolutely undemocratic.
Yeah.
okay, where you really need to be able to defend yourself. You know, do they have the evidence to say that you were in violation?
Yeah.
That's why I prefer to have these things brought under as Part 3 through the Provincial Offences Act. And in that way, then you could go in and then you could defend yourself and you
And
could question the authority.
And Robert is making the point that AMPS is basically laziness on behalf of municipalities. They should know, or ought to have known, that if they have the jurisdiction to create the bylaw. Yeah.
Yeah, exactly. Well, some of them have tossed their legal departments out, if you know what I mean.
Yeah. Well, yeah. Some of them, the legal department's actually embarrassment to their organization, but because it means that they have to comply with the law. and I didn't say anything about any municipality
We didn't
anywhere in
name
the
any
province.
municipalities whatsoever, okay? Or where they are located.
Yeah.
Or even if they're even in this province, we haven't mentioned.
Okay. So the question here is, what right do municipalities have to enact these rules? And I think ultimately that is going to be decided by the courts or by a government, because I can't see this as being, if we have a hodgepodge of rules, we're talking about Hamilton and we're talking about Toronto, two of the biggest cities in the province.
Yeah.
That's for
And
sure.
then what catches on is other municipalities going to do it. Ottawa, Kingston, Niagara, all these municipalities will start picking up and say, oh, why don't we have our own rent evictions bylaw? So they will all have it. And pretty soon the province will say, okay. And then maybe they're hoping the province is going to pick it up somehow. Maybe. I don't know.
Well, actually, maybe that is one of the reasons for doing it. But hey, yeah, and this may actually be way of we don't normally get political, so I probably should shut my trap at this point. But we kind of know that Hamilton's an NDP city, and that
oh, come on.
Olivia Chow, aka Toronto Mayor's an NDP, an NDPer.
I know, but there's also council there,
I
and
know.
there's also MPPs there that are conservative, and
I know.
they're all over the map.
I know they are. As I said, I knew I would.
And I think they do this in response to political pressure because there's a very high percentage of tenants in both communities.
Yeah,
so they organize themselves.
Don't get me wrong. I'm utterly, even though I
like Doug Ford, under Doug Ford government, we've had some pretty strict legislation that supports tenants too, under Doug Ford. So it's not like the conservatives are going to let everybody get away with things either.
Well, let's be blunt about this. We work all the time with both landlords who want to deal with things like N13s, and we also deal with tenants who are wanting to defend themselves against what they see as bad faith N13s. And let's add N12s in here as well.
Yeah, N12s are a big thing which we've been picking up lately.
Yeah, they're not that different when it comes down to it. And at the end of the day, the question of jurisdiction of these, as far as the landlord and tenant board, it is 100% the LTB. There is no other organization, and even though, for example, Thorold has a town bylaw that basically says that if you rent your property out, you must have you must have made a business license for renting your property out. All right, so a way that the city collects off of your rental business.
Is it the same for Airbnbs in Thorold, or?
Pardon me?
No, this is for Airbnbs, or do they have a separate bylaw?
I have no knowledge about the Airbnb bylaws. I do know that the rental bylaw system that exists within Thorold is actually it's a typical business license. I believe they do have vacation rental licenses as well. That's a different matter. But you have to have a tenancy license in order to rent out your building. But actually, what will happen when it comes, if you were to waive a thorough residential a tenancy license at the board will say, I don't care.
Yeah. We've had people who are living in illegal apartments.
Yep.
And the city has said, no, you got to close up your apartment. You got to go with it. And then something happens with the farm, and the tenant goes and fights the N13 because they have to convert it back to a full home or whatever, or maybe an N12 to convert it back into a full family home. Then what happens? They go to the board and they get turned down at the board. Okay, because they don't care. The tenant gets to stay, and the tenant gets to stay in an illegal unit. So, I mean, this is like, it happens a lot.
Yep.
Had to deal with that case too before, a case like that where, but like the landlord did his own N12 and did his own different things.
So this is only, these new bylaws are only going to increase the difficulties between the Residential Tenancies Act, the Landlord and Tenant Board, the court system, and the provincial offences potentially, or any AMPS type system. And in fact, actually, I would say that in some instances, they are almost out to bankrupt a landlord.
Yep. It's not even worth it being a landlord anymore. That's what I hear from a lot of people.
Yeah. Yeah.
I've had people that I've worked with over 20 years and who've been landlords, and they've had multiple units and everything for years, and they've had a good investment history of being landlords, and now they don't want to be landlords anymore because of the way the board has been dealing with things. I can only imagine what's going to happen with passing of these types of bylaws.
Well, I think there's going to ultimately be a lot of conflicts. There's going to be a lot of conflicts that are going to be created, and you're going to end up with a person getting a fine at the provincial offences court, and given authority to do something at the RTA, and there's going to be therefore some conflicts of laws at major levels, and that ultimately has to be decided by the courts or by government.
Yep. And this is something that needs to be consulted. There needs to be a lot of consultation with this. This whole question of renovictions, maybe there should be more consultation with the provincial government to try to set something that's a uniform law around Ontario, and make it simple enough.
Well, I think,
try to prevent abuses of it, but make it simple enough for people that need to use it.
Yeah, and I think that if you put if Toronto and Hamilton, jointly went to Doug Ford, he would probably listen.
Yeah, I think so. And then work with this, and develop it. This is something we can also do too. We do a lot of policy work to help draft things, and where we see a conflict, how are we going to address that? And then we can think of some ways and how that could be addressed, to make it easier for people, because you don't want to create confusion in a situation, and then confusion just leads to violations, unintended violations of particular laws or whatever.
Yeah, and that's the problem, is when people do something, they've always done it this way. They take the steps. We've always done it this way. Now you've invented a new set of rules. You've made it so damn complicated. I don't know what is up and what is down.
Yeah, exactly. And this is why we have to be really, really careful about how much more we put into it. Yeah. I agree there needs to be some monitoring and some ongoing assessment of what's going on with things, but to try to put some of these really strict steps into things, I think we may be complicating the matters.
Yeah. And as you said, what the requirements are based upon the Hamilton bylaws is that you need to have an application form. You need to have copies of the N13 notice. You've got to have the building permit, proof of the building permit in place.
An application for the building permit.
Well, actually, no, it says proof of the building permit in the
Oh, God, that might take a while.
right, exactly.
Yeah.
And a letter from a qualified professional indicating vacant possession is required. In other words, you need your your building planner or whatever.
Yeah, you got to get an engineer,
Yeah.
draft drawings, and all that stuff. How you
And
be
the other question which you need to think about, and I would urge that any landlord would think about this in advance anyway, is proof of an arrangement with the tenant.
Yeah.
Right? I would say that you should do that. That's not required today.
But you should do that anyways if you're going to
but
the board with an N13.
Yeah, you should do that anyway.
At least you want to show that you're doing things in good faith.
Yeah.
Okay? Like, say, for instance, a couple of your tenants want to move back into your renovated units. You want to show that, yeah, I've got another building over there just around the corner, and I got 2 empty units. So I've got them in there. Until I got this finished, and then they can move back into my new unit. So that kind of thing, to show them that you're taking steps, or adequately compensating them to move somewhere else if they choose not to accept the return.
And okay, part and parcel of N13s is the fact that you have to the renovation is of a certain in terms of if you're demolishing and rebuilding, for example, what you might well be doing is removing several 2-bedroom units to make 1-bedroom units.
Mm-hmm.
As there is a tendency in Ontario to have more single-person families.
Yeah.
So therefore, there's a need for more 1-bedroom units.
Yeah, some of them are doing that, or they just have 2 bedrooms, because some people who are single have a 2-bedroom unit.
I know. But
over once in a while, or a child who's an adult.
I know. I'm just saying.
Yeah.
There is a tendency to be moving to more 1-bedroom units, and so. But again, there's a lot of challenges with all of these, right? So I think if you're a landlord and you're in Hamilton or Toronto, you need to take extra precaution if you're going to be creating an N13.
Absolutely.
Right. And I think that's where we can leave it right now.
Yep.
Okay. So just to remind everybody, if you need to contact Invictus Legal, you can do so on 905-688-5598. Contact Angela at weareinvictus.legal, or me at peter@weareinvictus.legal. And our website is https://weareinvictus.legal. Right?
Yep. And we'll soon have an article on our website talking about what we talked about.
We're going to be putting a website article up about this.
I want people to understand this, because this is a new type of thing that's coming out. So,
okay. And I have just one more comment. Okay. Thank you from Robert. Okay. And also Angela's favorite line of the day.
Oh, yeah. What you've heard today on Spin Legal, whether it's this show or others in our series, is not legal advice. If you need legal advice, then please contact a paralegal or a lawyer, preferably us, but doesn't have to be. But as I said, this is an area of practice that we do, and we would enjoy hearing from you. And if you have anything that you would like us to talk about, or if you'd like to see something discussed in our show, please send us an email or put in the comments, or do something to let us know that you want us to talk about a particular topic, and we'd be happy to help you.
All right. And thank you, everybody. So have a great week, and we'll be back next Wednesday.
Okay. Take care.